Welcome to Law and the Machine, where artificial intelligence meets the legal system, liability, regulation, intellectual property, and the government's uncomfortable role as both rulemaker and AI adopter. The law wasn't written for this. The pitch has been heard many times now. AI models are like human students, learning from the vast oceans of available information, absorbing patterns, and then creating something new and original. That's the narrative AI developers often use to explain how their systems create music, art, or text.
And it's a narrative that underpins a very aggressive legal defense. Companies like Suno and Udio, which generate AI music, are facing massive lawsuits from the Recording Industry Association of America, the RIA, for allegedly copying copyrighted songs without permission. Their argument? This training process is quintessential fair use. They claim the copying happens in a non-public back-end process, unseen by human eyes, just statistical patterns being learned.
But what if that invisible back-end process isn't just learning, but actually memorizing? And what if the output of these systems isn't just new music inspired by existing work, but sometimes a near-exact replica, complete with a producer's audio watermark embedded in the track?
That's the crux of it. The forensic evidence increasingly suggests these models aren't just mimicking styles. They are, in fact, swallowing and sometimes spitting out the originals, including those distinctive audio tags that producers use to protect their work. It's a smoking gun that completely undermines the invisible learning narrative.
The legal landscape around AI and intellectual property is, to put it mildly, in turmoil. Looking at the Miscon Duraeus tracker of generative AI IP cases, it's a flood. We're seeing lawsuits against nearly every major AI developer across every creative field you can imagine. Authors, visual artists, 3D modelers, software developers.
It is a fundamental conflict. On one side, you have AI developers who need truly vast amounts of data to train their models, an almost insatiable hunger for information. On the other side, you have creators who are fighting for their basic rights to control their work and be compensated for it. These RIA lawsuits against Suno and Udio are at the epicenter of that battle.
And the stakes are enormous. The RIA, representing giants like Sony, UMG, and Warner, is alleging what they call mass infringement of copyrighted sound recordings copied and exploited without permission. They're seeking statutory damages that could reach up to $150,000 per infringed work. We're talking potentially billions of dollars.
Exactly. And the defendants, Suno and Udio, are leaning heavily on this fair use doctrine. Their core argument is that the copying of copyrighted music is a necessary and transformative part of an intermediate or back-end technological process. The claim is that because no human ever hears these intermediate copies during the training phase, no public-facing infringement has occurred. It's a sophisticated legal maneuver, trying to cast the creation of the AI model itself as the primary purpose of the copying, fundamentally different from the original works it was trained on.
So it's not about the output, in their view, it's about the internal mechanics of the machine, which they argue should be protected as transformative. It's almost like saying a student copying notes from a textbook is fair use, even if they later publish those notes as their own original work.
Well, the analogy they prefer is more like a student listening to music to learn to write their own songs. Suno's CEO, Mikey Schulman, has repeatedly tried to downplay the industrial scale of their data ingestion by framing it that way. He suggested on one podcast that their AI is just like a kid writing their own rock songs after listening to the genre. It's a very intentional framing.
The anthropomorphic machine, giving it human qualities to justify the scraping.
Precisely. By portraying the AI as a student rather than, say, a sophisticated, automated copying machine, the industry hopes to sway both judicial and public opinion towards a more lenient interpretation of fair use. It reframes a process of brute force data extraction as a creative act of learning and inspiration. But critics are quick to point out that this is a deliberate misrepresentation. One analysis called AI the world's most efficient plagiarism machine.
And Schulman himself has acknowledged the reality, stating that training on copyrighted music is stock standard practice that every AI company does.
So the narrative might be one thing, but the internal understanding of the practice is quite another.
Indeed, and that brings the discussion to the actual technical reality, which really challenges this invisible back-end argument. Ed Newton-Rex, who used to be VP of Audio at Stability AI before he resigned over the company's use of copyrighted data, has been a leading voice in debunking this claim. Through his nonprofit, Fairly Trained, he's published detailed analyses of both Suno and Udio's platforms.
What did he find? Is it really just learning style, or is there more direct copying happening?
His research demonstrates that these models are not merely learning abstract concepts like style or genre. Instead, they are quite capable of regurgitating near-exact melodies, harmonies, and chord progressions from well-known songs. He's provided examples of Suno-generated tracks that bear striking resemblances to songs by artists like ABBA, Oasis, Ed Sheeran, and Eminem.
So even if the AI companies try to block prompts using specific artist names, you can still get something uncannily similar?
That's right. He found that simple misspellings can often bypass these filters, allowing users to generate music that is unmistakably similar to the original copyrighted work. It's not about abstract influence, it's about direct, recognizable imitation.
And then there's the smoking gun mentioned earlier, the audio watermarks. How does that work?
This is perhaps the most damning evidence against the invisible back-end defense. There have been numerous documented instances of AI music outputs containing producer audio watermarks, like Cash Money AP or even Jason Derulo. These are short audio clips that producers embed in their instrumental tracks, often to prevent unauthorized use.
And the AI is spitting them out?
Yes, their presence in AI-generated music is direct proof that the models were trained on the original watermarked audio files, and that the copying was not nearly as invisible or transformative as claimed. It shows that the model has ingested and can reproduce the audio file wholesale, not just an abstract pattern. It's not just learning about a song, it's got the actual song with its embedded tag latent within its parameters.
So it's not just learning statistics, it's literally storing and reproducing specific, identifiable elements of copyrighted works. This seems to directly contradict the fair use argument.
It does. And there's a 2025 Chicago-Kent Law Review paper, The Files Are in the Computer, on Copyright, Memorization, and Generative AI, that provides the academic and technical framework for understanding this. It makes a crucial distinction between memorization and regurgitation.
Can you break that down?
Memorization occurs during the training phase. It's the process by which the model encodes near-exact copies of its training data into its parameters. The paper argues that when a model has memorized training data, the model itself can be considered a copy in the copyright sense.
So the model becomes the infringing copy, not just its output.
Exactly. And regurgitation is what happens at the output stage, the generation of a near-exact copy of that memorized training data, regardless of the user's intent. AI companies have tried to argue that infringement only occurs at the output stage and that the model itself is a neutral tool. But this research challenges this by asserting that the act of copying happens during training, when the copyrighted data becomes mathematically latent within the model. It argues, provocatively, that the files are in the computer, not just in the outputs. The potential infringement is embedded in the very architecture of the AI.
That's a significant reframing of where the legal line might be drawn. It shifts the focus from what the user does with the AI to how the AI itself was built.
It's a critical distinction because it means the fair use defense, which often hinges on the purpose and character of the use, becomes much harder to sustain if the model itself is considered an infringing copy. It attacks the very foundation of the AI company's argument.
This build first, clear later strategy, as some call it, sounds like a very specific business model. It's not just a legal tactic.
It absolutely is. It's a core component of the venture capital field business model that has dominated the AI sector. The prevailing ethos has been to build first, clear later. An early investor in Suno admitted to Rolling Stone that they likely wouldn't have funded the company if it had pursued licensing deals from the outset, arguing that it would have stifled innovation.
So copyright law isn't seen as a property right to be respected, but more as a barrier to be circumvented in the race to develop and scale new technologies.
That's the implication, and it's been incredibly lucrative. Suno, despite these ongoing legal battles, is reportedly negotiating a new funding round that would value the company at over $2 billion. Even their CEO, Mikey Schulman, conceded that if the lawsuits are successful, the company's not dead, though he admitted it wouldn't be good for us. The financial bet is clearly that the legal system won't catch up fast enough or that the cost of settlement will be less than the value created by ignoring IP in the first place.
This innovation at all costs mentality has certainly created a lot of wealth for some, but it has also galvanized a broad coalition of creators in opposition.
Absolutely. The Stealing Isn't Innovation campaign has been launched. Its argument is straightforward. AI companies are using creators' work without authorization to build platforms that directly compete with them.
And their central message is that a better way exists through licensing deals and partnerships, that responsible AI development is possible.
Exactly.
Now, the discussion turns to the paradoxical role of the U.S. government as both a potential regulator of AI and a major customer. This involves situations where the government's procurement and national security interests can inadvertently undermine its role in upholding the rule of law, including intellectual property rights.
The focus this time is on the ongoing lawsuit by major music publishers against the AI company Anthropic. The suit alleges that Anthropic engaged in massive copyright infringement by scraping copyrighted song lyrics to train its large language model, Claude. The publishers claim Claude not only copies lyrics during training, but also illegally reproduces them in its outputs.
So, while the U.S. federal court system is actively adjudicating whether Anthropic's foundational models are built on a bedrock of mass copyright infringement, another branch of the U.S. government is moving in the exact opposite direction.
That's the profound conflict. The Department of Defense and the intelligence community are rapidly adopting and integrating Anthropic's Claude model for mission-critical operations. This means the government is functionally subsidizing and legitimizing a company that may soon be found liable for what the publishers call systematic piracy.
It raises a very pointed and unresolved question for consideration. If a federal judge rules that Anthropic's foundational models are built on wholesale theft, will the Pentagon delete its new favorite intelligence tool? Or does national security provide a backdoor pardon for copyright infringement? Zooming out from these specific cases, these legal battles in the music industry aren't just about music, are they?
Not at all. These are test cases for the future of all intellectual property and digital labor in the age of AI. If the quintessential fair use defense put forward by Suno and other AI companies were to succeed, it would establish a sweeping legal precedent with profound implications far beyond music.
So a ruling in favor of the AI companies could essentially create a massive legal loophole.
That's precisely right. It would effectively mean that any digital content, whether it's software code, investigative journalism, scientific research, medical analysis, or visual art, could be freely ingested, copied, and commercialized by tech giants as long as the copying happens within this so-called invisible back-end process.
And that would fundamentally devalue the labor of human creators across the board.
It would. It transfers that value from the individual human labor to the companies that own the AI models, effectively granting them a free pass to exploit existing copyrighted works for massive profit. The legal framework, as it stands, was designed for a different era.
So the core thesis here is that copyright law, and indeed much of the legal framework, was designed with human actors and human-scale actions in mind. It wasn't written for machines capable of memorizing and indexing the entire history of human creative output and regurgitating it on command.
That is the central challenge. The current wave of litigation forces a confrontation between analog-era legal doctrines and the realities of digital automated systems. The outcome of these cases will determine whether the law adapts to protect human creativity and labor, or whether it will be reinterpreted to sanction a new form of industrial-scale automated appropriation.
Ultimately, it comes down to a fundamental question for society. Who gets to own the informational and cultural commons in an age where machines can learn everything? That's all for Law and the Machine. Join us next time as we continue exploring where AI and the law collide. If you found this useful, subscribe. We appreciate it.
The law will catch up, eventually.